Hello everyone. I am going to discuss about the topic performance of contract. Now let's start with the introduction. A contract places a legal obligation upon the contracting parties to perform their mutual promises, and it carries on until the discharge or termination of the contract. The most natural and usual mode of discharging a contract is to perform it. A person who performs a contract in accordance with its terms is discharged from any further obligations. As a rule, such performance entitles him to receive the other party's performance. Exact and complete performance by both the parties puts an end to the contract. In expecting exact performance, the courts mean that performance must match contractual obligations. In requiring a contract to be complete, the law is merely saying that any work undertaken must be carried out to the end of the obligations. A contract should be performed at the time specified and at the place agreed upon. When this has been accomplished, the parties are discharged automatically and the contract is discharged eventually. Now we will go to what actually performance of contract means. The term performance of contract means that both the promisor and the promisee have fulfilled their respective obligations which the contract placed upon them. For example, A visits a stationery shop to buy a calculator. The shopkeeper delivers the calculator and A pays the price. The contract is said to have been discharged by mutual performance. Section 27 of Indian Contract Act says that the parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under the provisions of this act or any other law. Promises bind the representatives of the promisor in case of the death of the latter before performance, unless a contrary intention appears in the contract. Thus, it is the primary duty of each contracting party to either perform or offer to perform its promise. For performance to be effective, the courts expect it to be exact and complete. That is, the same must match the contractual obligations. However, where under the provisions of the Contract Act or any other law, the performance can be dispensed with or excused, a party is absolved from such a responsibility. Next are the types of performance. Now, performance is an action of performing. It may be actual or attempted. Actual performance, when a promisor to a contract has fulfilled his obligation in accordance with the terms of contract, the promise is said to have been actually performed. Actual performance gives a discharge to the contract and the liability of the promisor ceases to exist. For example, A agrees to deliver 10 bags of cement at B's factory and B promises to pay the price on delivery. A delivers the cement on the due date and B makes the payment. This is actual performance. Next, attempted performance. When the performance has become due, it is sometimes sufficient if the promisor offers to perform his obligations under the contract. This offer is known as attempted performance, or it is also known as a tender. Therefore, tender is an offer of performance which of course complies with the terms of the contract. If goods are tendered by the seller but refused by the buyer, the seller is discharged from further liability given that the goods are in accordance with the contract as to quantity and quality, and he may sue the buyer for breach of contract if he so desires. Accordingly, a tender of performance may operate as a substitute for actual performance and can effect a complete discharge. Now, with this regard, Section 38 of Indian Contract Act says, where a promisor has made an offer of performance to the promisee and the offer has not been accepted, the promisor is not responsible for non-performance, nor does he lose his rights under the contract. For example, A contracts to deliver to B 100 tons of basmati rice at his warehouse on 6th December 2015. A takes the goods to B's place on the due date during business hours, but B, without assigning any good reason, refuses to take the delivery. Here, A has performed what he was required to perform under the contract. It is a case of attempted performance, and A is not responsible for non-performance of B, nor does he thereby lose his rights under the contract. Now, we'll discuss about the contracts which are not to be performed. A contract need not be performed when its performance becomes impossible. When the parties to it agree to substitute a new contract for it or alter it. Thirdly, when the promisee dispenses with or remits wholly or in part the performance of the promise made to him or extends the time for such performance or accepts any satisfaction for it. Now, we'll be discussing about by whom the contract must be performed. The contract must be performed by the promisor himself. In the case of a contract involving personal skill, taste or credit, example, a contract to paint a picture, a contract of agency or service, the promisor must himself fulfill the contract. Section 40 states thus, if it appears from the nature of the case that it was the intention of the parties to any contract that any promise contained in it should be fulfilled by the promisor himself, such promise must be performed by the promisor. Secondly, by the promisor or his agent. In the case of a contract of impersonal nature, example, a contract of sale of goods or a contract to lend a sum of money, the promisor himself or the agent must fulfill the contract. For example, A promises to pay B a sum of money. A may fulfill this promise either by personally paying the money to B or by causing it to be paid to B by another. Thirdly, by the legal representatives. In case of the death of the promisor before performance, the liability of performance falls on his legal representatives unless a contrary intention appears from the contract. For example, A promises to paint a picture for B by a certain day at a certain price. A dies before the day. The contract cannot be enforced either by A's representatives or by B. Thank you.